Lululemon is known for its trendy but rather expensive athletic apparel that is quite popular with women. In 2014, the company made the headlines as BuzzFeed referred to them as the fashion industry's biggest patent troll because Lululemon had patented 31 of its clothing designs and then used those patents to sue competitors. While they agreed on a confidential settlement with Calvin Klein and G3, who had been sued in 2012 for violating a design patent on Lululemon's yoga pants, the clothing manufacturer Hanesbrand refused to give in that easily. Lululemon accused Hanesbrand of having copied tank tops that were sold under the brand Champion at Target. Hanesbrand was given 15 days to stop production. However, the company decided to file lawsuits against Lululemon instead, arguing that the retailer obtained a patent on an obvious design and that its drawings of the top are vague and indefinite. This raises the question if the patent should have been issued by the U.S. Patent Office in the first place. There are voices who can claim that some of Lululemon's merchandise is not unique enough to be entitled to intellectual property rights. For example, while a yoga mat decorated with phrases specific to the company's ethos appears legit, it is not clear when it comes to shorts with a zipper in the back or sport bras with thinner than usual straps. Hence, it remains difficult to determine what is unique enough. More important, those developments could have serious consequences for consumers since not everyone can afford Lululemon's clothing. The retailer charges $82 for its cheapest yoga pants. If Lululemon sues every brand whose clothes look remotely like theirs, this could ultimately result in consumers being prohibited from buying sports bras that are built into baggy shirts, for instance. Thus, Lululemon would expand their monopoly and market share. The lawsuit between Hanesbrand and Lululemon was settled, although terms are confidential. Nevertheless, BuzzFeed wrongly referred to Lululemon as a patent troll because what makes an entity a troll is that it is non-practicing, which means that it doesn't use, make, or sell goods that embody the patent. It merely uses the patent to extort money from would-be infringers, what distinguishes Lululemon from traditional patent trolls. The manufacturer with headquarters in Vancouver is not the first company in the fashion industry to patent designs. Gucci, Chanel, Hermès, Dior, and many more depend on legal protection of their intellectual properties. That being said, those cases appear to be more distinct than Lululemon's. Although companies want to use patents to protect their unique designs, with the rise in their usage stores like Lululemon are limiting the fashion options for everyday people. When discussing the issue of patents in fashion, it is important to understand what factors are making up the story that is being told. In this particular story with Lululemon creating patents on its designs, in order to fully understand the story, the topic, audience, and composer must be fully analyzed. However, with this particular story, there are two sides to it. The first is a story being told by those who believe that Lululemon is a patent troll, and the second is those who are supporting Lululemon in their efforts. To begin, the subject or topic of the story is very important in how it is logically being presented. Both storytellers agree that with Lululemon patenting 31 of their designs, they are making it impossible for other companies to replicate their products. However, the Lululemon supporters believe this is not a problem. They are protecting what is rightfully theirs and are not becoming a patent troll. They define patent trolls as groups that are not producing the item that is patented, but instead are benefiting from the money they make off of breached patents lawsuits. On the other side of the story, those against Lululemon believe that the company is going to start a trend of monopolies in the fashion industry. With Lululemon patenting so many of their designs, they soon will be the only ones who are able to produce athletic clothing, creating a monopoly over the industry. With the start of this control, other companies will begin to patent their own designs, and monopolies over individual types of clothing will arise. Whether Lululemon actually is a patent troll or not, there is a large risk of this monopoly trend occurring, which speaks greatly to a wide majority of the population. This story is incredibly relevant to all middle-class Americans. For those people that cannot afford expensive brands like Lululemon, they rely on stores like Target to buy their clothing. Yet these stores will no longer be able to provide clothing to middle-class Americans if the entire industry is monopolized by these high-class, expensive companies that have their designs patented. Although the composers of this story definitely are on extreme ends of whether Lululemon is destroying the fashion industry or helping themselves to prosper, they are able to address their arguments with sources from Lululemon, the Fashion Law Institute, and the United States Patent and Trademark Office. Regardless of the credibility of the storytellers, they never address or observe who was affected by these patent lawsuits outside of the companies. In understanding this story, it is critical that all the voices that are involved and affected are represented. Yet, without discussing the effects on middle-class Americans on the potential monopolies that could occur if fashion patents are not controlled, half the story is being left out. The main stakeholders in this case are Lululemon and the companies that they sued. Calvin Klein, G3, and Hanesbrand are all well-known companies in the fashion industry, each company selling clothes for people of different socioeconomic backgrounds and fashion tastes. The majority of articles that cover the lawsuits are focused on Lululemon's reasons for suing and also the impact these lawsuits will have on the fashion industry and design patents. What is commonly left out is the reaction of the companies that were sued. Most of the cases resolved out of court with Calvin Klein and other companies reaching an agreement with Lululemon privately. As an audience, we have no idea as to how the agreements were reached and if any future protocols for situations like these were established by either side. The voices of the consumers of these brands were also left out. Although Lululemon and the majority of G3 company brands, including Calvin Klein, sell high-end clothing, Hanesbrand lines can be found at shops such as Walmart and Target. The shoppers of Hanesbrand may have opinions regarding being able to purchase the same styles at cheaper prices compared to brands such as Lululemon, and should be brought into the conversation at some point. Although most of the articles show sympathy to the designers of Lululemon styles that they claim to have been copied, the articles do not consider the people that wish to purchase Lululemon styles but cannot afford them.